Good afternoon, and thank you for joining us today. I ask that you please keep your cameras on. Questions will be answered at the end of this event, approximately 7 to 10 minutes prior to the end. I will ask you to just raise an emoji of your hand, and we will call you. So, again, welcome and thank you for joining us today for our program on leading the charge, transforming legal practice through technological innovation. Today's event is hosted by the Maidis Law Society, Canada's hub for Jewish legal professionals and law students. The Maidis Law Society, named in honor of the esteemed David Maidis, stand as a beacon for legal excellence and human rights advocacy. David Maidis, a distinguished lawyer and a human rights activist, has been a crucial figure in B'nai B'rith, Canada for over 3 decades, contributing significantly to some of the organization's most important cases. As senior legal counsel, Mr. Maidis exemplifies the spirit and vision that guides the Maidis Law Society. With the rise in anti-Semitism, the Jewish community needs now more than ever an activist legal society. Ensure that your name is included in Canada's Jewish history by becoming a charter member of this unique network. Today, I have the privilege of introducing our distinguished speakers, Mr. Garry Wise and Dr. Aviv Gaon, who will share their expertise on the technological innovation in the legal field. Just a little background of the speakers. Mr. Garry Wise graduated from Osgoode Hall in 1984 and called to the Ontario Bar in 1986. Mr. Wise founded Wise Law Office in 1986 and is a senior lawyer and notary. He has completed advanced training in family law, mediation, and a Bachelor's of Arts degree in psychology. His Toronto law practice focuses primarily in the area of employment law, family law, civil litigation, personal injury litigation, estate litigation, and small business consultation. Mr. Wise is a prior chairman of the Legal Affairs and Advocacy Committee, Big Sisters Association of Ontario, where he also serves as a member of the executive committee for 2 years. He's also the primary contributor to the award-winning Wise Law Office blog and has also developed the Wisely, Canada's mobile legal research tool, a free iPhone application enabling users to research Canadian case laws, statutes, and regulations via Canly. Mr. Wise has contributed to many publications. He has been a continuing legal educational presenter on social media, legal ethics, Web 2.0, and security issues, as well as has been featured in numerous newspapers such as the National Post, Toronto Star, Law Pro magazine, and so forth. Dr. Aviv Gaon graduated from Reichman University, where he obtained both his LLB cum laude and LLM. He further obtained his PhD from Osgoode Hall, York University. Dr. Gaon's work is in the area of intellectual property, and technology earned him the IP Osgoode David Vaver Medal for Excellence in IP Law in 2019. Currently, Dr. Gaon is a research fellow at IP Osgoode Center for Intellectual Property and Technology and a professor at Reichman University. In 2019, he also joined the intellectual property journal IPJ editorial board, a leading Canadian journal for intellectual property and technology research. Dr. Gaon is also a member Gaon is also a member of the Bracing for Impact Artificial Intelligence Challenge Conference Series organized committee. These conferences facilitate legal discussions about Canadian tech policy and attract academic scholars, tech companies, and government leaders. So thank you again for joining us. I will, in this valuable program, it is my pleasure to start off the conversation by asking Mr. Wise the following. Looking back to when you first started practicing, what was the technological landscape in law like? And what were the main challenges lawyers faced without today's technology?
Well, first of all, thank you for inviting me to join this discussion today. I'll say off the top that while I can talk quite a bit about what I've experienced in terms of technological development throughout my career, when it comes to what's happening today and in the future, I'm more of a student than anything else. And I'm looking forward to learning, as I'm sure the other members of the audience are, about the different ideas about where we're going. But where we came from in 1986, when I was called to the bar, it was a very different world. We used typewriters and dictaphones, snail mail. And I often tell people that the way we used to work back then is we would write a letter on a file, put the file away for 2 weeks, because that's typically how long it was going to take to get a response. As the technology advanced, everything started happening faster. The amount of paper itself, and now digital documents multiplied exponentially. And I'd actually suggest that the job of being a lawyer has become much more complicated in many ways, while also easier in a lot of ways. Needless to say, when I started, we had no conception of what was coming. There was no internet to speak of. There was no social media. There was no Google. Legal research was done mostly manually at the library. And although quick law existed, it was in its infancy back then and prohibitively expensive. So it was an extremely different era. As each technology emerged, the legal profession, sometimes slowly, sometimes rapidly, adopted the technologies, and increasingly these technologies have become incorporated into our day-to-day practices to the point that we don't really think about it anymore. But in terms of the challenges lawyers had back then, not very different. The technology has definitely assisted us in communications and preparing our documents, but the issues that we address of people going through extremely difficult experiences in life and needing the legal system to help guide them through, that hasn't changed any material way. I think you're muted, Elite.
I'm sorry. I'm sorry. Uh, Dr. Gaon, how do you envision the legal profession should prepare for AI's growing influence? Are there specific educational or regulatory changes you think would best equip lawyers for an AI, a augmented future?
Well, thank you, and thank you for inviting me to speak in this session. I'm very excited to be here with you, even remotely. I have to tell you that I just came from a conference in Tel Aviv for the law bar, for the Israeli law bar. So it's quite interesting to have an experience talking with Israeli lawyers and now talking with Canadian lawyers. So it's quite an amazing experience for me that day. So the AI is something that's I've been research for I think the last decade, and a few years ago I had a discussion with my professor, with Professor David Weber, that some of you probably probably know. And we spoke about AI and about the potential of AI to to our life and to our practice. And when I think about this conversation, I try to envision what we thought about AI just a few years ago, and what we know about AI today. It's quite remarkable. Because a few years ago, when I was asked whether AI is going to replace us lawyers, is it something that is going to change our legal life completely? I would tell you, no. I don't think it will, replace lawyers. I don't think it will be something that will consider a threat to our legal profession. But today, with the emergence of open AI, with the emergence of generative AI, with what is happening, I mean, the last year in the legal profession, I can tell you that lawyers that will not be able to work with those tools will probably become obsolete. So I think that the most important part, and I hope that we'll have a chance to talk about that even further this during this session, is that we have to learn and we have to teach our students and our legal practitioners how we can use those tools, and use those tools in efficient and prudent way. Because as we have with any legal tool and any technology that came that sprout to our life the last 20 to 30 years, every technology or any technology has benefits, important benefits. But in the end, if we want to learn how to work and how to use this technology in the right way, in the carefully, then what is probably going to happen, that will make some very bad decision with these technologies. And when we talk about the law profession, if us as lawyers will use those tools without taking consideration to what those tools can do, and what are the risks of using those tools, we might harm our clients and our clients' interests. So I think that the future is going to be, as someone said, the future is going to be that the next lawyers are going to be lawyers that know how to work with AI, and the lawyers that will not be able, or will not work with those tools, will probably become obsolete. So that's my vision, at least for the next 5 years, because farther than that, I think it will be very, very difficult to predict.
Thank you. I would like to actually ask both of you the following. One of you works very closely with law students, and the other works closely with clients and other legal professionals. How do you experience your experiences actually differ based on individual wanting to utilize technology over face-to-face connections? And how do you think this has shifted due to COVID, and how will it continue to adapt over time?
Well, I'll start on this. This event that we're at now is very typical of my day. Virtually everything I do is by video conference now, whether that's internally within my office or with clients. I can't remember the last time a client actually wanted to come to my office to meet with me. So as a consequence, I would say that remote work, remote connection is the norm that in my professional life we're now dealing with. The people in my office prefer to work remotely. We do get together once a week for a firm video meeting where we do everything from catch up with each other on a personal level to file management. And we've established a routine around that in my office. But I see in the immediate future no appetite at all to return to the old days. And I'm wondering whether the law office, the physical law office as we know it, is going to survive. I'm not feeling any real clamoring for that to continue within my office.
Dr. Owen?
Yeah, of course. I don't have an experience with practicing law. I didn't practice as much as Gary, obviously, but I can share some of his I think thoughts and idea, and I can agree with him on two. I think on two levels. First, when you start conferencing, my experience with Zoom, with this technology advancements, is that It used to be, if we look into post the pre-COVID era, I had to travel. I had to travel quite extensively in order to talk to you. I would like to have a chance to speak with a Canadian audience. I would have to travel to Toronto or to any other part in Canada. And I think that what happened today is that we are able to actually reach out to more individuals, to more people, and to speak with them and to share ideas in a more efficient way. And that's, I think that what happened with the Zoom and with any other global technology is that we all became more connected. And we all share some sort of like a bigger community that happened, I think, in the last 3 or 4 years. So that's something that I can see as a very good thing. On the other hand, we lose the personal touch. We lose the time that we have to talk, not formally. So now we have a formal discussion. Formal discussion is something that's very important, but for me, the non-formal experience is even more important. And when I teach students, and now we have an options, we can teach an in-person class, or we can teach a Zoom class. And I will say that if you teach students the in-person class, the one that you actually travel to commute to the university and have these discussions, you find out that many students are actually more interested in having these connections before and after class. And these connections are very important, in my opinion. And it's something that is part of a human connection. And it's part of, if I look at it from an educator, as an educator, it's something that's very important for me as an educator to talk to my students in an informal way too. So I think that the future is probably going to be try to mix between those two. So I don't think that we should skip or try to let go of the in-person meetings with the in-person teaching and classes, but we definitely can use those tools in order to make our life even better and more efficient in a way. So I think that if we can find the right way to mix between the in-person and the Zoom or online meetings, I think it will be best not only for for us as practitioners, but also for us as teachers, professors, and in the academia.
Thank you both. Mr. Wise, given your expertise, that what aspects of legal practice have stayed strong, traditional, despite technological advances? Where have you seen the greatest resistance or challenges to integrate new technologies?
Well, that's kind of two questions. So why don't I deal with the second part of it about resistance? It's probably going to be hard for many people in this group to accept, but there was a time when the legal profession was not particularly technologically adept or interested. And that didn't change easily. When I think about the first innovations, very antiquated as they are today, but the first innovations I experienced in my career, the fax machine came in around the time I articled. So in 1984, when I was articling, I became aware for the first time of this strange thing called a fax machine that allowed us to send cases that we had researched to a lawyer who was involved in a case in the Cayman Islands. And in the same way that we're talking about the difference between meeting in person or meeting online, the notion that you could actually send paper halfway across the world instantly was something that was very new and very mind-boggling to me at the time. But the fax machine came into accepted usage probably within 2 or 3 years, so that you couldn't possibly run a law office by the time I was called to the bar without a fax machine. So that was one innovation that everybody jumped onto. But the first computer, personal computer that I encountered in my office was probably 93. And back then, you could tell who was on a PC because their letters arrived properly justified with beautiful fonts and it looked very, very different from a typewritten document. So you could immediately tell who was in the next generation and who wasn't. And once again, within a year or 2 years or 3 years, the legal profession kind of joined as a herd. Um, the the internet was the next innovation, and once again, the legal profession was not quick. In fact, when I did my first website, there were a lot of people um, being very negative about it, that lawyers were being commercial by having websites. And that was at a time when advertising simply wasn't permitted by the Law Society of Upper Canada as it was then known. So just the whole brave new world of lawyers having these public online faces was something that was very new and that lawyers were naturally kind of cautious about. And even now, with AE starting to rear its head in a more serious way, we're hearing a lot more from the voices of caution than the voices of adapting within the profession. But we know it's going to happen, and we know that the lawyers that jump on the new technology more quickly are probably going to wind up with a step up and a step ahead. But what that actually means in today's technology is unclear. And I know our law society has issued certain guidance, again, around being cautious with AI and being very careful about what you do in terms of understanding the technology, protecting confidentiality, verifying AI generated outputs. And I think that's the one I can relate to most, because the first time I tried ChatGPT, I asked it to do two things, if I'm remembering. The first was to prepare a demand letter. And it did a demand letter, and it was pretty good. It was probably on the level of any demand letter that a self-represented litigant would do. It certainly wasn't better than a letter any lawyer with a template or precedence would manufacture. But I didn't encounter any problems with that. But the next thing I did, and forgive the narcissism involved, but I asked it to produce my biography. And it got my biography remarkably right, except where it didn't. And what's now become known as a hallucination, we used to just call it a mistake. It had me at the wrong law school in the wrong period of time, and that made me very cautious. And then when we started reading press reports about hallucinations appearing in factums and case briefs that lawyers were submitting because they had AI do the research for them, well, I think that caused a lot of us to take a step back and say, not yet. So I'm still in the not yet period when it comes to AI. I understand that it's going to be able to do an awful lot for us, but what I'm hearing is coming is evolutionary. It's not the revolutionary stuff that we're reading. It's going to allow us to do practice management a little more effectively, which is really good. Probably document generation will be more efficient and faster. Will it really put people out of work? I doubt it. The last several rounds of technology that didn't put people out of work. In fact, it created more jobs because there was more to be done and we needed more hands to do it. And if we can figure out a way to actually create those kinds of efficiencies, the legal profession will be extremely interested. But for now, I'm a little doubtful. So essentially, every new technology will have its period of resistance, like the resistance I just expressed about AI, followed by early adopters jumping right in there, showing the rest of the world, the rest of the legal world, how it's done. And then when it catches on, the legal profession will, if history proves to be repeating itself, the legal profession will jump on like a herd, all at the same time to the next technology. And whatever changes occur At that stage, we'll just set the stage for the next level of changes to come afterwards. But I think my main thesis in this discussion is that change and technological change is not new. It's always been happening, certainly throughout my career. I expect it always will happen. I expect there will be innovations, but I don't think these are the real innovations that we're seeing right now that are going to change the world.
Thank you. Um, Dr. Gaon, as AI continues to evolve, how do you foresee it affecting intellectual property rights, particularly around authorship and ownership? Do you believe our current IP laws are equipped to handle these advancements?
Well, thank you for this question. So that's basically what I researched during my PhD at Osgood, and I think the answer is quite complex. So let's start with what I think and what the vision for AI and IP. So when we think about intellectual property, I don't know how many of you work in this field, or but you probably learned a bit about IP, and you learned about the theories around IP and why we actually want to award rights to anyone. So the main reason, at least according to North America standards, is that we wish that people will create more creations, will create more creation, will invent more patents, will write more book. So we want to protect the creation that were already created in order for these individuals to be incentivized to create more. So I think that was the main reason. It works well on humans because we, as humans, we want and we have wishes, we have needs, and obviously it can be easily triggered by our will for gain profit. AI is something different. And the reason it's something, and the reasons why it's so different is because when you think about AI and like any other machine has an integrated will. We actually the one that program AI's will to do certain things. So when we think about IP in the future, I think the first thing is that why we want to offer protection or to award protection to AI. Because when you think about humans, you want to incentivize humans to create more and to maybe to invent more. But with AI, it's something that is distinct. It's something that is done almost automatically. So why will I be willing to award this protection? Another argument that I think it make even more sense is that when you think about AI, it's basically a creation proliferation. Think about how easy it is to generate pictures today with any other generative AI tool. Think about how easy it is to write and to create text. So when you think about that, if we will offer or award protection to anything that is created by AI, basically nothing will be able to be awarded any IP protection. So we have to think about those ideas because we don't want to limit protection for AI creations. So that's I think one element that is very important to understand. The other thing and the other issue when you think about AI creation and we think about intellectual property is the fact that when we think about artificial intelligence in general is something that might be able to create things that are more creative than whatever humans created. So when you think about the standards that went today with copyright, for example, you look into copyright and we look into patent law, they are both have very basic standards for creativity. When you think about copyright, we talked about originality. So originality is a very basic standard. And when you think about originality, it's something that is it's very easy to sustain. It's very easy to be able to create something that is considered to be original under copyright standards. The same thing with patent. When you talked about with patent law, it's quite easy to gain patents today. When you think about inventorship, AI could be more creative and could create more patents than anything that humans can create today. So by awarding IP rights, we basically limit the potential or the opportunities for other humans to create either any copyrightable item or any patent. So I don't think from a theory base, I don't think it's wise to offer protection for AI like the standards that we have today. We have to find a way to limit this protection, and we have to find a way to frame this protection in a very, I think, in a very different way. And then it gets me to the other elements of your question: IP in the future, intellectual property in the future. Here I see a very big challenge, because I think that we as humans are going to control creation at least for the next 10 years. So obviously we will have to have any type of legal standards. I think IP is going to sustain at least for the next 10 years. But I think that we'll have to develop a new benchmark, a new standard for creativity, a new standard for creation. And it might be that when we talk about AI creation, I think that we might require to create sui generis legislation that will identify AI in a distinct way than any other human creation. So I think that IP law will have to change, and to change dramatically, to be able to sustain this new emergence of AI technology.
Thank you. I appreciate it. The following question I address to both of you. Technology has a transformative impact on traditional legal practices. How do you think international collaboration can support Jewish legal networks in adopting these shifts?
Aviv, you want to start on this one?
Yeah, for sure. Um, Well, I think this is exactly what we're doing here today. I think this is an example of how we can harness this technology in order to create a bigger community. For me, it was always, quite difficult to find, to be part of this, to be part of the legal community in Canada. To be honest, I was not even aware of this community existed until you reach out to me. So the fact that we have these organizations, and the fact that we are able to have this communication between us and to meet new people from the community, it makes the community bigger. So if you look into history and we think about Jewish communities worldwide, it was always quite difficult to find those communities. So when we think about in the past, we lived in certain city or a certain country, and it was quite difficult for us to reach out to individuals from other cities or other countries. Now we are actually able to develop this new workshop, this new community, and by through this technology, we are able to have these discussions and maybe to raise ideas that might be different. So I can share my perspective that from my community, and you can share your perspective from your community, and we can have a discussion, and you can address certain issue that or common issues that we value as important, and by that way we are able to create a better and stronger community.
Yeah, I agree 100% with your comments. What current technologies allow us to do or collaborate and communicate in a way that is unheard of in human history. And an event like this, that while it's more of a lecture slash questions type of format, getting groups of people together to actually deal with a specific issue is now so easy. To create an action plan through this kind of collaboration has never been easier. To publicize the action that is contemplated with social media and other forms of communication like email has never been easier. And cumulatively, that gives the community so much potency and ability to handle working together on common issues and common action, that I think we're just at the very cusp of learning how to do that. And certainly the challenges the Jewish community has faced here in Canada and throughout the world over the last year plus have caused that kind of mobilization. I've seen that more at CEJA, where I've had some involvement with the labor and employment group, which is handling advocacy on behalf of all kinds of Jewish Canadians who are experiencing difficulty in their workplaces. And I've seen that that operation from its infancy develop some real reach in terms of its ability to actually help people. But this collective that is represented today is just as important. And I'm going to do a quick plug that for lawyers being involved in the Jewish community. And one of the things that wasn't on my resume that was mentioned in my bio is that I'm the president of the Jewish Camp Council of Toronto. And the one thing I can say is that organizations like mine and every organization so desperately need lawyers to be part of the work they do, whether it be on their boards or their committees, or to be involved in an organization such as this one with B'nai B'rith. For all of you who came out today, kudos to you for participating in that way, and just letting you all know the Jewish community really needs you. So find a place. Your time will be respected and extremely appreciated.
Thank you both, and thank you, Garry, for trying to get more people on our side and advocating for the cause. I truly appreciate it. I would actually like to further ask you is the following. Access to justice is a major topic when discussing technology in the legal sector. This is especially relevant to the Jewish community who are increasingly facing legal challenges. How do you think emerging tech can enhance access, and what barriers remain?
Well, I'll reiterate much of what I just said in terms of how the community can reach out to help people. But I think access to justice is a larger problem that is actually a government problem. And we as lawyers can do our best to help people stick handle through all of the difficulties they have, but getting access to the courts. But the reality is that our courts are filled with self-represented litigants now, and people are increasingly finding the legal avenue to be too expensive and too inconvenient and onerous to participate in. I think that the real future of technology is none of what we're talking about, but it's more the predictive technologies that will allow decisions to be made either by judges or by machines in the future with algorithmic assistance. The kind of law that I do, some of it requires very customized approaches, but much of it doesn't. And much of it is highly capable, susceptible to being fully automated, up to and perhaps including much of the decision-making process. I think that that's beyond the pay grade of this discussion. But in terms of access to justice, I'm not sure that AI is going to make it easier for people to have their day in court at any point. Again, if history is repeated, it's going to make it more difficult because as the technology improves, either you know the technology or you don't, as Aviv said, and those who don't are going to be left behind. When we talk about the lawyers who don't being left behind, we're not just thinking of the lawyers, we're also thinking about the clients who will be left behind if they aren't part of this technology and the technological changes ahead. But the real access to justice work needs to be happening at a government level. Even our law societies and our legal agencies like the CBA, they can't meaningfully make an impact on that.
Thank you so much.
I can just, I mean, I can just echo his comment, and I totally agree. I just want to add one more thing to the discussion about access to justice, because I think it's a very important issue, and it's a topic or a subject that we have been dealt with, I think, for the last 10 years, and we were quite worried when AI started to get into the existence, and something more people become more aware of AI. I think one of the issues was whether AI is going to actually create more problems to access, or it could make access to justice more available. And I think that the answer, as Gary said, that is in one way, on one part, you can say that AI make access to justice more efficient, in a way that it's easy for us to predict the outcome of the outcome of the case. It might be easy for us to submit certain documents to courts. In the future, we might have an AI system that will be able to help, getting into the first, logistic or technical barriers that every one of us facing when we deal with the courts. Just think about, I saw a few interesting examples of AI apps that only purpose is to explain legal process to individuals, and just this very simplistic AI app is something that help people understand the process, help people understand what they need to do, and this is something that is definitely helping us to make this courts and make this the legal process more available. On the other hand, as we said, and that as Gary said, whenever technology came into power, and whenever technology make more available, that means that firms that will be able to recruit people with the skills to use AI better, or firm that will employ better and sophisticated AI systems, will be able to produce and basically to provide better advice to individuals, and the other people will not have access to those tools at all. So this is the way my internet. Oh, yeah, I think we have some issues there. Yeah. Yeah. No, I'm actually at university. We have some I think technical issues at the university today, given some of the recent events that we have earlier. So yeah, I hope it will be fine. But I think that was my comment about access to justice.
Thank you. I'd like to ask you further, how do you envision the legal profession should prepare for AI's growth in influence? Are there significant educational or regulatory changes you think would best equip lawyers for an AI augmented future?
Yeah, maybe I'll just turn my video, and then maybe you can hear me better, or it's fine now. Just want to
We're
make
hearing
sure.
you
Can
We
okay.
hear you
you can hear me?
okay. We just
Okay,
we
great,
can't
great,
really
great.
see you.
Okay. All right. Sorry about that. Okay. So again, this is a very good question, and I think that's one of the main challenges that AI will probably we have to deal with in academia, is something that relates to the way that you can actually evaluate students. I think that this is something that I actually want to comment about, because when you think about the academic profession, the legal academic profession, law students usually ranked by their writings. So seminars, most of the classes that I had at Osgood was all, were all about seminars. We had a seminar, and then we had to submit a final paper. And I think that all those assignments become obsolete today, because you can't really evaluate students' writings when you have those AI apps that can make these writings more and more efficient. So I think that one of the big challenges that we're going to have to address is to change the way that we teach students, to change the academic sphere from seminars to workshops, from something that is more theory based to something that is more practical based, and that's a whole new game, in my opinion.
You're muted, Elise.
I'm sorry. On my end also, technical difficulties. I couldn't unmute for some reason. I apologize. I'd like to ask you both if you can share a case study uh, where technology tools directly contributed to a favorable outcome or more efficient resolution. What lessons did it prove?
I can start on this one. I I could simply say everything. Every case I've ever done has benefited from it, but there's one case for some reason it jumps out at me. It goes back to it's not that recent, 2013, but it was a domain name dispute. A client of mine, very prominent legal marketing organization, had a competitor that, as new internet suffixes came out, the competitor basically stole his name and registered the client's name with a different, not a .com, but a .net or something like that. And we wanted to enforce our clients' intellectual property rights, and all of those matters were dealt with by online dispute resolution. Through the National Arbitration Forum, which I think was in Milwaukee at the time. I might be wrong about that. But there were no courts, there were no in-person appearances. Everything was dealt with by documentation. The documents that were required were very clearly specified. Even though I had never done one of them before, it wasn't like navigating Ontario's court forms and courts, where it's highly likely that there's going to be some problem with the documentation when you prepare it the first time. But it was extremely simple, extremely streamlined, and the documentation was submitted. And within, I think, 2 months from beginning to end, we had a favorable result, and our client's domain name was protected with relatively little cost, certainly no inconvenience, and a system that really functioned as it was intended to. So that's an example of how the process itself was entirely driven by the technology. It could have been done in a prior time. I suppose it would have required travel to go to another country to enforce these rights at great expense, and undoubtedly numerous adjournments and false starts before there was ever a resolution. But that would be an example of a process that was actually tailor-made to utilize the technology, and one that worked really well. In Ontario, we're now beginning to see, after a long delay, we're beginning to see our courts becoming a little more efficient in terms of online services and online filing, certainly video conferences. So we're going to see more and more of that as our system updates itself. And there are certain judges like Justice Myers in Ontario that are very much advocating for this technological advancement. It will come, but it's still in its infancy.
Thank you so much. Dr. Gaon, if you have,
Yeah.
yes.
Yeah, so I mean, I can share just there is as Gary said, there's so many different examples. I think in the last 10 years or so for using the technology in general, specifically in this area of the legal field and legal tech. I mean, I can only attest to to our legal system in Israel. I think that in the last 10 years or 15 years, we've been moved pretty fast in relates to digital submissions and everything. And I think that today most cases are actually working quite efficiently within the digital sphere. You don't have any physical submissions anymore. Everything is done online, so that
We are
Looks like
having
we lost
trouble
you.
hearing. I think we lost him. So I will address my final question to you before we take questions.
Okay, I'm back. Sorry,
Oh,
sorry.
sorry.
Yeah, I'm sorry. There is some connection problem with with Wi-Fi. So what I just will conclude just what I said, like, because my example is because I'm teaching in the academia and university, and one of the best thing that happened, I think, in the last 2 years, technology related, that the court started broadcasting from courts. So instead of taking the students to watch certain cases in court, now I can use it online. And I can use it as part of my classes, as part of my seminars, and I think it's quite an investment. So I'm very pleased with this, with this specific example. Yeah, sorry.
Quite all right. Thank you so much. As we have 6 minutes to our session, perhaps we should see if there are any questions. If not, I have so many more questions to ask. I don't think we even have sufficient time. I can see that Rocky Polak has a question. Please go ahead.
I'm interested in knowing your reaction to the use of uh, technology inside it, inside a legal practice involving criminal law. Let me give you the worst example that I experienced as a judge in Manitoba. Um, we had kids at the Manitoba Youth Center who were confined because of COVID in custody weren't brought into the courtroom unless it was really a vital court appearance. And so these kids who suffer from FASD uh, um, are kids who can't put together a series of executive functions. Like, take that door into the courtroom, your lawyer will be the guy on the left, the judge will be wearing the robe. Processing that is very difficult for them. What happened was, of course, we used the efficiency of cameras, microphones, to have them appear in a little closet in front of a judge, their lawyer, who they have only seen on a screen because they weren't allowed into the jail to see these kids. It was again on another screen, and there were serious miscarriages happening right in front of me when it was clear that there was no access to the court for this poor kid on video screen. And my concern is, as we get excited about efficiency, criminal law, we can repeat that in all sorts of other kinds of scenarios. I'll be quiet now.
I just obviously that's a terrible story that the courts need to be sensitive to as video conferencing starts to replace, in most cases, in-person appearances. And other than the human check and balance that the court can provide itself, I don't know what you do about that. And particularly in cases where counsel and clients really don't have a strong enough professional relationship at an early stage, especially for the lawyer to even know what the concerns that need to be before the court may be, very, very difficult. But this is an example of how the technology, while bringing people closer in many ways, really takes away a vital element in human connection that on its best days, our courts have been most responsive to. But our courts need to have those insights to really understand the equities, I would suggest, of the cases that are being decided. And if the technology is making that more difficult, as you're pointing out, then that's a red flag that our judicial system and legislators need to be very mindful of.
Thank you, Garry. Dr. Gaon, do you have anything to add?
Yeah, I can just say that I totally agree with Gary. I think this is a problem, and this is again, it showed us that when you deal with technology, you can't just implement technology without any checks or balances. I think this is exactly what we need to think about. I think those examples are why we need a very strong supervision system that will be able to track, highlight, flag certain problems, and try to find a way to address those. I don't think that, for example, if you allow uses of certain elements within the courtroom, it means that it's something that you can use for all, for all cases, for all purposes. So you have to find, to find the way, the right balance. And this is, unfortunately, it will take time. And in this time, people might get hurt. And this is something that we need to understand. This is the price of technology.
Thank you. Moreover, I'd like to thank both our speakers for participating and educating us on this topic. I would also like to thank everyone who joined us today in this important event. Furthermore, I'd like to thank everyone that was involved in putting together this event. IT, research, Lily especially, and marketing. Should you have any additional questions or would like to hear more on this topic or any other topic, I urge you to email Matus Law Society directly so we may answer any and all questions, concerns, or future things that you might want us to hold a session on, speak about, and so forth. So, in conclusion, thank you everyone for coming today, and I wish you all a great rest of the day and week.
Thank you
Thank
so
you.
much. Thank you.